I want to first welcome some special members that are here. Our Women's Advisory Council was formed in 2005. These women were invited to help advise us on how we, as a community bank with full financial services, can do a better job of serving the unique needs of women, and they've done a fabulous job. The Women's Advisory Council was formed not only to advise the bank, but also to take on a real important education piece, because we knew from the get-go, from hearing from people like you, that you just needed to know more. You needed to know more about what services are available, what it means to build an estate plan, what it means to try to start investing with an investor in a brokerage company, what it means to make a loan. You just needed information, and we decided that we would grab that and take responsibility for that. Thus, we have these sessions a couple of times a year. We also were asked by you from evaluations to give us a little more information on detailed subjects that were probably too detailed for these sessions, so we started individual workshops. And so feel free to contact us and sign up for any of those workshops, because there's some really good topics and we have found folks enjoy them a lot. We are going to have three scenarios that your speaker is going to provide you with. It's going to be the good, the bad, and the ugly of some things that we've seen about estate planning. It's going to be a really good program. Would like for you to hold your questions to the end, so jot them down if you would like, for sake of time, because we promise you we'll get you out of here by 1 o'clock. So with no further ado, I want to introduce our speaker, who will make her way to the front in a few minutes. Her name is Dee Davenport. She's a senior VP in our trust department. She's also a licensed lawyer and is absolutely awesome at what she does. So she is going to tell you about
Thank you. Yay, thanks for coming, and thank you. This is a powder horn to help keep the powder dry, in case people have been wondering what that is. So welcome here. We're so glad you could be here. And I look forward to talking to you about 3 case scenarios that we've entitled The Good and the Bad and the Ugly. And we think they'll be fun to give you a little illustration about the world we work in, and also how it might affect you. So, the first one, good, the good. The point of the good is to remember that you, with your estate plan, are the person who decides who receives your legacy. You decide who your beneficiaries are. So, and you also get to decide how to communicate that information to them. So, let me tell you a little story about a couple who were extremely fortunate. They fell in love, and their love lasted for a really long time. And I'm going to call them husband and wife. And the husband is now age 50, and the wife is now age 70, and they've been married for 30 years. She had children from her first marriage. They didn't have any children together. So they spent a really wonderful 30 years, and husband helped her take care of, nurture, and grow their wealth together. And she decided, because of some circumstances we won't go into, but what she wanted to do was she wanted to give her wealth to her husband. And she wanted to give the bulk of it to him, and instead of to her children from her first marriage. So this is an unusual thing, but it's not unheard of. People get to choose. It's their choice. And so then the issue came up of, well, what do you think's going to happen when those children find this out? You think they might be upset? Do you think they might want to file a lawsuit? and create all kinds of problems. So under advice of their attorney, they found out that Arkansas is one of the 4 states in the United States that has a concept called a pre-death will statute. So basically, what the wife did was she had her attorney write up her last will and testament, and she executed it appropriately, and then they filed it in the court, and they invited all of these children to the court so that mom could look everybody in the face and say, this is what I want, this is my decision, and this is what I want to do. So eventually a court order is entered so that when the wife dies, there's an order validating her will. And any issues that are pending to be decided can be decided right then while everybody's there and present. So the second thing that this illustrates is communication. What is the right way to communicate your wishes? We've had a whole ethics presentation about the difficulties people are having in doctors and physicians and hospitals and places like that, because families really struggle. But even though they have the written direction from their loved one, don't give me antibiotics, don't intubate me, it's really hard to make those decisions. So if the loved one has told them, look, this is what I want, it's a lot easier for the family to do it. And so it's not just about the stuff, it's about other things too. So even though this is a lot of money, these cases that we're talking about can apply to anyone, whether your state is small or medium or large, whether you've already got one in place or you haven't taken the time to do that yet. This can apply to everybody. So that's the good information. It's your choice about the legacy, and it's your choice about how to communicate. And we do encourage families to communicate if possible. And this is a really severe way to do it, but it's a way, and it's an option. Children from the first marriage, mom happily married for 30 years. She wants her husband to inherit her fortune. The couple expect a dispute, and they institute an action for validating the wife's last will and testament. Now, she can change her will, and if she does, then it invalidates the court order and we're back to ground zero. Okay, so we ready to go to the bad? All right. This is a really unbelievable fact situation. And it basically illustrates the importance of who you choose to carry out your estate plan. That's a big decision for you to make. And there's lots of options about that. And we're going to talk about an option that Mr. and Mrs. Stone chose. This was about 50 years ago that they put together their estate plan. And he was an employee at Walmart in the early days. And so their wealth came from lots of Walmart stock. So people who are familiar with estates in Arkansas have seen this fact situation before. A little bitty market value of stock turns into something really large. So when they were making a decision about who should be their successor trustee, because they were using trusts, they decided to choose their prominent and brilliant professional. And it might have been a CPA or it might have been a lawyer, but it was a professional along those lines who was very well respected, very prominent, and very smart. So just to give you a feel for this case today, 1/4 of that estate is valued at over $7 million. So that's just to give you a feel. But these facts, just to remind you, can apply to all sizes of estates and trusts. So Joan was the only beneficiary, and she started noticing these really strange distributions out of her trust. And she was a little eccentric, even though she was brilliant and determined. So it took her a long time to get any attention because she kept saying, something's not right, something's not right. You know, and she looked a little eccentric, and the prominent trustee, you know, it's hard to believe. So finally, she got a law firm here in Little Rock, and Delta Trust became the successor trustee. And here's what we found, that this trustee had loaned $3 million to his good buddy, unsecured. It was defaulted and never collected. We never found that money. We don't know where it went. The second thing that we found he'd done is that he'd taken $120,000 out of the trust and bought the lot next door to his home in the name of he and his wife's name. There was no benefit to the trust or the beneficiary for any of this. And then the other big thing that we saw, and this is just what we saw, is that he caused the trust to wire $500,000, $500,000, to an out-of-state bank to pay off a loan that he and his wife had personally guaranteed. So we couldn't see any benefit to the trust or the beneficiary for this. And it took a lot of work and a lot of time from a lot of people, but finally he did get indicted. He is in federal prison, and of course he's lost his licenses. So he's hopefully not available to work with some other public on this. So that's an example of a bad. So there's a wonderful legacy that's going to last generations. So you know, 1/4 of this trust is worth about $7 million, and we know about $3 million, $4 million. We did collect some of it, but most of it's never been collected. So it would have been about a $10 million trust. But for this rogue trustee, a very reputable, smart person, you would think you would be able to trust them. It was never recovered. So the thing that we want you to be aware of is that this is a lot of responsibility for people. Also, when you appoint someone as your attorney, in fact, under a power of attorney, you know, you want to make sure it's people who are available and know what to do. That's one of the values of a corporate trustee. Delta Trust does that, but other corporate trustees are available because it's harder for one person to go rogue in that kind of environment. There's a lot of oversight. There is internal, the trust group, management watches over it, and then you've got trust committee and a board of directors, and then you've got internal auditors and outside auditors. So hopefully you've got enough oversight for safety there if somebody does go rogue. Doesn't happen that often, but when it does, it's not good. All right, so there you go. That's the bad. That's bad enough, don't you think? All right, so let's talk about the ugly. And this is really something that could affect everybody, everybody's estate plan, because just about everyone has what we call the qualified plan account. Okay, so an example of that would be an IRA, a 401k, any kind of pension or any money where it grows without income taxes being paid on it. In other words, income taxes don't get paid until it's distributed out to whoever it's distributed out to. So one of the phenomenons about this type of account is that the documents that we described in that first bullet, that list of documents, they don't affect these accounts, okay? So these accounts go by a thing called beneficiary designation. So it's a form that the holder of the account manages and has the ground rules over. So this is a true story, and this one went all the way to the U.S. Supreme Court. And it's about a couple whose love did not last as long as our first couple. But it started out great. In 1971, William and Liv got married. And this was a second marriage for William. And he had a daughter from his first marriage, and her name was Carrie, and that was the only child, and there wasn't a child from the second marriage. So William and Liv married. They didn't have a child. William had a child named Carrie from the first marriage. In 1974, 3 years after they got married, he went to his employer, who is DuPont, and he said, "You know my qualified plan. Well, I want my wife, Liv, to be the beneficiary of it." So they said, "Okay, here's the piece of paper, fill it out, give it back to us," and he did. So Liv is she's the beneficiary of this retirement account, this qualified plan. So then, alas, about 20 years later, they divorced. Liv and William divorced. And in the negotiations for this, Liv actually signed an agreement. I am disinherited. I have no rights to any of William's accounts. I specifically have no rights in the DuPont account. And she signed it. And then in addition to that, there was a court order. We grant the divorce, and Liv doesn't have any rights to any of William's accounts. Okay. So about 3 years later, William dies. Carrie's thinking, this is his only daughter, that account's going to be mine. This DuPont account is going to be mine. And Liv figures out somehow that William had made a mistake. And after the divorce, he never went to DuPont and changed the beneficiary designation. So the beneficiary designation said Liv is the beneficiary, and y'all, it's worth about $400,000 now. So Liv kind of wakes up to this and she goes, even though I signed everything and said I don't want this and I pledge allegiance and we have a court order, she decides to fight for it. And so she and Carrie are now in hand-to-hand combat, and they go through the first level federal court and the second level federal court, and finally it gets up to the Supreme Court. And guess who won? His second wife realizes the $400,000 because she was the last one listed as the beneficiary on this beneficiary form given to DuPont. And even though Liv had signed away her rights to this money, she'd agreed in a contract, and there was a state court order that was entered that said she didn't have a right to it. The thing that governs these accounts are the plan documents. And even the will and the trust and all that don't govern. The plan documents govern these accounts. So this is a real common issue. We work really hard to help our clients, everybody does, to make sure that we get that, support people in getting that right. So the question is, what accounts are there out there, and are the beneficiary designations in alignment with what you want to happen? Because it is your choice. But don't rely on a state court order, because we know federal law trumps state law, all the way to the Supreme Court. So we just wanted to let you know, because I'm coming to the end, so if you have any questions, start thinking about what you want to know more about, that planning is really doable. It may seem overwhelming, but you can take it in little pieces. And there are a lot of really good professionals, all kinds of good professionals to back you up and to help you, look out there and think about what is the experience that you want your heirs and your family to have, the charity to have, whoever it is that you care about. Really think about what you want that to be, and then it's just a matter of mechanics. And there are a lot of people that know what those are and can guide you through that. So thank you so much for listening, and if you have any questions, I'd love to engage them with you.